Mr. Eisen, what you've just stated is so utterly and completely absurd, it's almost impossible to even respond to it. This case will be reversed on appeal. The level of egregious reversible error that was demonstrated by this judge and by the prosecutors is absolutely off the charts. I've never in my entire career seen anything even close to it. I think you recognize that. I think the vast majority of the American people recognize that. I really want to focus on the equal protection and due process issues that are so clearly evident here. And the fact, Mr. Eisen, that you keep going back to 2016 and what occurred in 2016 is extremely important from that standpoint. Ms. Foley, is there a due process and equal protection aspects to statutes of limitations?
Well, I mean, statute of limitations can be, I guess, evaded, I suppose, in ways that could violate the due process or equal protection.
Well, and in fact, in this kind of a circumstance, that's what you see. We've got a situation where the alleged crime was committed in 2016, and they had to bootstrap it to something that occurred years later to try to resurrect what was really a dead case. And the way that I look at statutes of limitations as someone who practiced law for well over 30 years is that people have memory issues. That's why there's a statute of limitations. Can you remember what you were doing on June 13th, 7 years ago or 4 years ago? I'm sure Mr. Ambassador cannot. There are statute of limitations because trying to drag somebody before a tribunal 5 and 7 and 10 and 12 and 15 years down the road, by its very definition, especially if we're talking about a potential criminal prosecution where someone is going to lose their freedom, do we really want someone getting up and being able to say, 25 years ago, I was attacked in a dressing room, I have no evidence, can't tell you anything about it, don't even know what day of the week it was, don't know what month, don't know what year, but for goodness sakes, we know what happened. So we have the state of New York, and they come in and they pass a law saying, well, we're not gonna have a statute of limitations for this particular crime or this particular individual. Wouldn't that be considered a violation of this gentleman's due process rights?
Yeah, I mean, I think it's part of the overall context, which again kind of shows the political motivation, the uniqueness of this case. I mean, Ambassador Eisen talks about the 10,000 cases. Well, I've read most of those cases too. None of them approach the uniqueness of this case and the obfuscation of the theory here. For example, usually the underlying offense that is intended to be committed is grand larceny, grand larceny, grand larceny, insurance fraud, things like that. Very straightforward facts. But by making the underlying offense here federal New York election law, which itself required proof of unlawful means, which then hinged upon FICA, tax laws, falsification, business records, it just got more and more and more unclear exactly what Mr. Trump was being charged with. So all of these facts suggest that there is a shocks to conscience due process violation here, in addition to the notice problems I've pointed out.
Well, and I think that there's the due process issue, but Mr. Bailey, let's turn to you and let's talk about the equal protection aspect of it. As you've just described, Ms. Foley, this is one case against one man for one purpose. And in fact, the governor of the state of New York has said it. Look, everybody, don't worry, we're not coming after you for these kinds of fraud claims. We're just going after Donald Trump. Isn't that the antithesis of the foundation of our Constitution that is based upon equal protection and equal application of the law? Have you ever seen anything like what they have done to Donald Trump in their effort to destroy who they perceive to be their political enemy? Mr. Bailey.
I have never seen such an egregious assault upon the tenets of equal protection as when government officials in the state of New York claim that they are specifically targeting one individual and will not use the same laws against anyone else. But I want to go back to the due process issue briefly, because everything that's being said here is further amplified by the fact that Section 175.10 of the Code of State of New York, which forms the basis of the 34 charges, has an affirmative defense that requires the defendant to get a preponderance of the evidence. How can he go get his evidence if you bring the claims late? Statute of limitations are intended to prevent sandbagging of claims.
Exactly right. And in this particular circumstance, and what we've seen in the other persecutions against Donald Trump, they absolutely had to violate those basic tenets in order to go after him. It is absolutely an egregious violation of the law. It is a level of constitutional malpractice, the likes of which I've never seen. And Ambassador Eisen, I think that if you were being honest, you would agree with that. With that, I yield back. Mr. Attorney General, are you above reproach?
I'm not above criticism. I'm not sure what you mean by reproach, but of course, you're totally free to criticize me, and I expect
Yeah, as
you will.
American citizens, we can criticize you. We can criticize all of our government employees, can't we?
Absolutely.
Because you've seemed to whine quite a bit today about being attacked or people challenging the decisions that you've made. I actually think that Daniel Greenfield, a contributor to Front Page Magazine, may have said it best when he said that a justice system can survive those who challenge the prosecutors, but it can't survive those who prosecute the challengers, which is kind of the situation we're in with the Biden administration and you at the helm of the Attorney General's office. Attorney General Garland, in March, Chairman Jordan and I sent you an oversight letter requesting documents and information following the release of an undercover video indicating that the DOJ was working with the IRS to use artificial intelligence to surveil bank accounts of Americans in a clearly unconstitutional manner. The undercover video featured an IRS official privately admitting that the IRS had been using AI to spy on Americans' bank accounts en masse in real time. The IRS official further stated that the Department of Justice and Inspector General controlled this AI-powered warrantless surveillance system, not the IRS. Attorney General, would you agree with me that if the federal government were operating this form of financial surveillance program, there would be serious Fourth Amendment as well as other statutory and civil rights implications, considering that there is no individual probable cause and no search warrants are being obtained?
I would be stunned if the Justice Department has the kind of AI
Would you-
capabilities that you're talking about.
Would you agree with me that? Would you agree with me?
To learn about this.
Would you agree with me that if they were engaging in that kind of surveillance, it would have serious Fourth Amendment implications?
I can't understand the kind of surveillance that you're talking about. Fourth Amendment prevents unreasonable searches and seizures without a warrant. If that's what we're doing, then of course that would violate the Fourth Amendment.
Okay, so I would request that you go back and read the letter that Jim Jordan and I sent to you. That might clear up your confusion just a bit.
I'll be happy to do
Now, while the committee has been following up with the department about this matter for months now, the department only replied with a formal response to the committee late last week. In the department's response letter, a DOJ spokesman, the Assistant Attorney General, Carlos Iriarte, stated that the department is, quote, not aware of the department using any AI program that reflects the description in our March 20th letter, end quote. But saying that the chief AI officer is, quote, not aware of the department coordinating with the IRS to use AI to unconstitutionally spy on Americans' financial records is very different from saying unequivocally that the department is not doing so. Why won't the department just give us a clear answer as to whether it is actually using AI to spy on American citizens' financial records?
I'll be happy to take your letter back, and apparently you already have received a letter. I'll take it back and we'll see whether we can get you a clearer letter for you.
I would appreciate that. I want to turn to another serious issue, the infiltration of our tribal communities by the Mexican cartels because of Joe Biden and Mayorkas's open border. As chair of the Subcommittee on Indian and Insular Affairs, I have heard from tribes across the nation about this issue. In your written testimony, you actually mention how the department is working with tribal partners to disrupt cartel supply chains and that the department is zeroing in on the Sinaloa and Jalisco cartels. However, in April, the president of the Fort Belknap Indian community testified to the department's failures, stating, quote, we don't have help from the FBI, the Border Patrol, the DEA, that has jurisdiction on federal lands, which are reservations. Attorney General Garland, his testimony comes from a tribe where the Sinaloa cartel operates with near impunity in its region. Drugs have devastated the community, reservations have become part of the cartel supply chain, and the Mexican cartels are intimidating Americans testifying before Congress. Yet the FBI and DOJ are largely absent. The tribe's experience runs in direct contrast to your testimony. Have you been in contact with any of our tribes about the impact that mass illegal immigration, human trafficking, and drug smuggling are having on their members?
Not only have I been in contact with the tribes, I've been on the reservation in Montana and Alaska. The answer to your question is Congress is not giving us money for FBI agents to go into the reservations.
Oh, so this is Congress's fault that you won't do your job?
It's Congress's
This
fault.
is Congress's fault that you won't protect
I will do
our
my-
reservation, that you won't protect our reservations from the consequences of the Biden and Mayorkas open border policies. That's Congress's fault, not theirs.
If you give us money for more FBI
Oh, you
agents
need more
for the
money for FBI
reservations,
agents.
they will
How about
go
if
to the
they just
reservations.
enforce the border? How about if you ask them to enforce the border?
Special Counsel Hur, when you determined that no criminal charges should be brought against President Biden in this matter, you focused on the specific facts surrounding the classified documents, where President Biden stored them, and on his memory and age. You wrote that President Biden's, quote, memory was significantly limited during his recorded interviews with the ghostwriter in 2017 and during his interview with the Special Counsel's Office in 2023. You also expressed concern that prospective jurors would be persuaded by President Biden's presentation as a sympathetic, well-meaning elderly man with a poor memory. Your assessment, however, was focused on how President Biden would currently present to a jury if he stood trial. Is that correct?
That was an element of my explanation to the Attorney General for my decision. It was not the only element.
Okay, that wasn't my question, but it was one of the things that we were considering was his current state of mind, his current memory. Correct?
One of the things that I considered would be how, if a trial, whenever a trial theoretically were to be held, how President Biden would present himself to the jury if he elected to testify.
Okay. You did not compare President Biden's current memory or condition with his memory or condition when he was in the Senate or when he left the vice presidency and took the classified documents subject to your investigation. Is that right?
Actually, I believe that's not correct, Congresswoman. One of the things that's in the report is an assessment of the president's memory based on recordings from the 2016-2017 timeframe, recordings of conversations between Mr. Biden and his ghostwriter, and comparing that with the president's memory that he exhibited during our interview of him in October of 2023. So there was a comparison there.
Okay, so, but unless there was some issue undisclosed to the American people during his 50 years in office, you found that Mr. Biden fully understood his legal responsibility related to the handling of classified materials, which is why you concluded in your report that Mr. Biden, quote, willfully retained and disclosed classified materials after his vice presidency when he was a private citizen. You state that on page 1, correct?
I believe that what I stated on page 1 was that we identified evidence that Mr. Biden willfully retained classified information after the end of his vice presidency, but ultimately we concluded that the evidence was insufficient to warrant criminal
I
charges.
understand that. Please listen to my question. What I'm getting at is that Mr. Biden fully understood that he could not keep classified information at his home as both a former senator and vice president. Isn't that right? He understood that, correct?
My understanding is that based on the evidence, my assessment was that a jury.
That isn't what my question was. Please listen to my question. My question was that Mr. Biden understood when he was a senator and vice president that he could not keep classified materials at his home, at his garage, and in other offices. Is that fair?
I don't think that's accurate, Congresswoman, because when Mr. Biden was vice president, he was authorized to have classified material in his home.
But after he left, he knew that he was not entitled to keep classified information at his home, correct?
After he left, there is evidence to suggest that he knew that he could not legally have classified information in his home. However, there is evidence with respect to his notebooks that he believed he was authorized to keep the notebooks at home based on precedent.
Based on precedent. You know, I guess the way that I would put it is this. President Biden knew better. He knew that he wasn't entitled to keep these documents from when he was a senator, and he knew he wasn't entitled to keep these documents after he had left the vice presidency. But because he's now suffering from an impaired memory, as you so delicately put it, he got away with it. Is that fair?
Congresswoman, what I stated in my report is that there's certainly evidence that some jurors could infer to suggest that Mr. Biden willfully retained and disclosed national defense information. But in my judgment, the likely outcome of a trial, the probable outcome of a trial, is not a conviction.
I have represented a variety of clients over the years in actions against the federal government over, in fact, several decades of time.
It's been my experience that the federal government, the DOJ specifically, has essentially unlimited resources to go after and prosecute citizens and will spare absolutely no expense in doing so. It has also been my experience that the DOJ is not only overly aggressive in these cases, but makes it clear that part of the reason for such aggression is to make an example of the poor soul who is the subject of such action. In other words, so that other people will not engage in the same kind of conduct. Mr. Hur, having been a long-term DOJ prosecutor, can you please explain why those people without the last name of Clinton or Biden are typically treated quite differently and seem to be the only ones who are never held accountable for violating the law?
Congresswoman, one of the things that I explain in my report is the fact that there are historical precedents with respect to former occupants of the White House and their retention of classified materials after they leave. So
I'm asking specifically about Mrs. Clinton and Mrs. Hillary Clinton and Joe Biden.
Congresswoman, I don't have any opinion to articulate with respect to the investigation relating to Mrs. Clinton.
I yield back.